So, good morning, everyone. Now, I'm going to discuss with you all some of the important acts under labor laws. Under that, Employees Provident Fund Act 1952 is one of the most important and one of the most grievous act. Under this, I am going to discuss with you all the important provisions, terminologies, and the landmark judgments given by the Supreme Court and the High Court, which will help you to understand what are the implications if specific provisions are not complied under this act. So the objective of this Employees Provident Fund Act is to provide the financial stability and security to an individual where the long-term savings of an individual is accumulated in a fund known as Employees Provident Fund. These funds can be utilized by the individual after their retirement. So let's talk about the important provisions and applicability of this act. This act is applicable to every factory or establishment where 20 or more employees are employed directly or through a contract. And if we talk about the wage definition prescribed under this act, it states that the PF contribution is required to be calculated on the basic wages and the dearness allowance, but there are certain exclusions such as food allowance, house rent allowance, overtime allowance, bonus, commission, etc. For the purpose of applicability, there is a ceiling limit prescribed under this act. The ceiling limit is of rupees 15,000 per month, and the due date for monthly contribution is required to be made by 15th of the next month. There are certain provisions in respect of interest and damages prescribed under this act. Section 7Q of this act deals with the interest provisions and section 14B deals with damages. Section 7Q states that 12% per annum interest would be levied for every single day where there is a delay in the EPF payment. And the damages prescribed under Section 14B is in addition to the interest but is paid by the employer. If the delay is up to 2 months, the damages would be 5% per annum. In case the delay range between 2 months to 4 months, it would be 10%. In case it range between 4 months to 6 months, it would be 15%. And in case delay exceed beyond the 6 months, it would be 25% per annum. These damages would be paid in addition to what interest prescribed under 7Q. However, the inspector under PF department have a discretion to avoid these damages if specific conditions or at the parties required, or if he is satisfied that there is due compliance under this act. The penalty prescribed under this act is that the employer is liable to fines for being a defaulter under this act, and this can be extended up to imprisonment of 3 years and fine of rupees 10,000. Now, under this act, all the permanent employees, temporary employees, contractual interns, these all categories of employees are covered under this act. Now, here is an example on your screen where we have considered two cases where we have to consider different salary components as mentioned on your screen. Can any one of you can tell which of these two cases is correct according to you?
Case 2, sir. Case 2 is according for is right.
Okay, anyone else? So very right. Case 2 in this example is correct. We have to consider basic and special allowances for making PF deduction, and HRA is excluded from the definition of term basic wages, which I will discuss with you more in brief with the help of case studies in my next slide. Now, this term basic wage, which is defined under Section 2B, it is one of the most important definition prescribed under this PF Act. Now, this term basic wage means all emoluments which are earned by an employee while on duty or on leave or on holidays with wages in accordance with the term of the contract of employment and which are paid or payable to such employee. But there are certain exclusions made under this act. These are: first one is the cash value of food concession. Second one is the DNS allowance, HRA, overtime, bonus, commission, and any other similar allowance. Now, this one I have highlighted in red. Any similar other allowance, I will discuss you with more in brief in my next slide. That what does it mean and what category of allowances come under this preview. And the last one is any present made by the employer. We have to read this section, section 2B, in consonance with section 6 of the Employees Provident Fund, which further include DNS allowance, which deemed to include the cash value of food concession, retaining allowance. Now, the crux after considering these two sections is PF contribution is required to be paid on basic wages, DNS allowance, which deemed to include cash value of food concession, and the retaining allowance, but it does not include the HRA, overtime, bonus, commission, and any other similar allowance. Now, there is a question in your mind, and what would be the done with the food allowance, canteen allowance, special allowance, or any conveyance allowance is given to the employee, then what would be the criteria to include in the term of basic wages and in what situation we have to exclude. For the purpose of this, I have inserted some of the important case laws in which judgment is made by the Supreme Court regarding this. Our first case is the Bridge and Roof Company case. This is the most important case where the Supreme Court has given its judgment in the year 1962. This case law is regarding to the term basic wage definition. And the key issue of this case was whether the production bonus is to be included within the term basic wages and can be taken into account for calculating the provident fund contribution or not. So basically, in this case, the company had a production bonus scheme in force which provide for payment of production bonus which is over and above wages fixed. Production bonus is required to be paid on certain rates specified in the relevant scheme when the output reaches certain number of tons per year, and no such production bonus was to be paid when the output is less than X tons per year. Means employee को certain criteria fulfill करना है कंपनी के अंदर in terms of production in order to avail this production bonus or what we say an incentive. If some employee have put this fulfill a criteria to produce certain number of articles in a specified time frame, then only they will receive this production bonus. Otherwise, they are not entitled to receive. So the judgment and the reasoning made by the Supreme Court is that the basis for exclusion in clause 2 of the exception of section 2B is that it is not earned in all concerned by the all employees of the concern is excluded from the term basic wages. तो इस लाइन का ये मतलब है अगर आप कोई भी अलाउंस अगर आप सभी इंप्लॉयज को दे रहे हो इन ऑल डिपार्टमेंट इन ऑल दी कंसर्न डिपार्टमेंट इन योर ऑर्गेनाइजेशन देन ओनली इट वुड बी द पार्ट ऑफ टर्म बेसिक वेजेस सपोज आपके यहाँ कोई ट्रैवलिंग अलाउंस है और आपके यहाँ सपोज 100 एम्प्लॉयज है और आप वो ट्रैवलिंग अलाउंस सिर्फ 20 या 25 एम्प्लॉयज को दे रहे हो then that allowance would not be the part of term basic wages unless and until you give that allowance to each 100 employees in your organization. Second point is the payment of production bonus depends upon the production and it is in addition to wages. It is an incentive to higher production and it is the nature of incentive wage. प्रोडक्शन बोनस एक तरीके का इंसेंटिव है जो एम्प्लॉयज को दिया जाता है जो एक स्पेसिफिक क्राइटेरिया फुलफिल करते हैं. प्रोडक्शन बोनस इज नॉट द पार्ट ऑफ टर्म बेसिक वेजेस. बेसिक वेजेस तो आपको देना ही है. प्रोडक्शन बोनस इज ओवर एंड अबव द बेसिक वेजेस विच इज पेड टू सम नंबर ऑफ एम्प्लॉयज who fulfill certain criteria. And the last and the most important point is that the performance may even fall below the base or standard, but the minimum basic wage will have to be paid whether the base or standard is reached or not. However, the workers produce beyond the base or standard, what they earn is the basic wages, but the production bonus or an incentive wage. So anything over and above basic wages is termed as production bonus or an incentive. To give you more clarity regarding the term basic wages, there is a most recent case law for you all in which the judgment made by the Supreme Court recently on 28th February 2019. It is the most recent case and the most important, where the Supreme Court had ruled that all allowances on question are to be treated as wages for the purpose of provident fund for effectively binding the definition of purpose of PF. Now, in this case, there is certain criteria prescribed by the Supreme Court that in what scenario a specific allowance come under the definition of term basic wages. इसमें एक प्रिंसिपल बताया है इस केस के अंदर. वो एक कॉमन प्रिंसिपल है जो आप लोग फॉलो कर सकते हो इन ऑर्डर टू डिटरमाइन कि एक स्पेसिफिक आपका अलाउंस बेसिक वेज की डेफिनेशन के अंदर आएगा या नहीं आएगा एंड अकॉर्डिंगली यू हैव टू पे कंट्रीब्यूशन टू एम्प्लॉय. सो द की एस्पेक्ट्स ऑफ दिस रूलिंग वाज अ यू एंड नो प्रिंसिपल. ये एक प्रिंसिपल है जो कि सुप्रीम कोर्ट ने विवेकानंद विद्या मंदिर केस के अंदर प्रिस्क्राइब किया जो कि है यूनिवर्सली नेसेसरली ऑर्डिनरली. अगर आप कोई भी अलाउंस आप सभी एम्प्लॉय दे रहे हो इन ऑल डिपार्टमेंट्स ऑफ योर कंसर्न, देन ओनली इट वुड बी द पार्ट ऑफ टर्म बेसिक वेजेस एंड देयर आर सर्टेन की इंग्रेडिएंट्स prescribed under this principle. First one is that the allowance must not be in variable in nature. वो allowance variable nature का नहीं होना चाहिए. Second one, it should not be linked to any incentive for production warranting greater output by an employee. This point I have discussed in my previous slide, which is regarding to production bonus. कोई भी allowance आप इन द फॉर्म ऑफ प्रोडक्शन बोनस या इंसेंटिव के तौर पर एम्प्लॉय को दे रहे हो जब वो एक आउटपुट रीच करता है बियॉन्ड अ स्पेसिफाइड लिमिट, then it would not be the part of term basic wages. Third, it must be paid across the board to all employees. Means वो अलाउंस आप सभी एम्प्लॉयज को दे रहे हो. ये नहीं है आपके यहाँ 100 एम्प्लॉय है तो आप 20 से 25 एम्प्लॉय को फूड अलाउंस, कन्वेंस अलाउंस या ट्रैवलिंग अलाउंस दे रहे हो. आप अगर सभी को दे रहे हो तभी वो पार्ट बनेगा, अदरवाइज इट वुड बी नॉट बी द पार्ट ऑफ टर्म basic wages. And the last one is it should not pay specifically to those who avail the opportunity. ये नहीं है जो पर्सन दूर से आ रहे हैं आप उन्हीं को दे रहे हो. सिर्फ आपका कॉमन होना चाहिए वो अलाउंस सभी के लिए, चाहे वो दूर से आ रहा है या पास से आ रहा है. आई एम जस्ट टेकिंग द एग्जांपल ऑफ कन्वेंस अलाउंस और ट्रैवलिंग अलाउंस व्हाट यू से. So these four ingredients are made under the U and no principle prescribed under this case. Now our next case law is based on the term of कॉन्ट्रैक्ट वर्कर्स। अगर कोई प्रिंसिपल एम्प्लॉयर किसी कॉन्ट्रैक्टर को हायर करता है अपनी ऑर्गेनाइजेशन के अंदर, तो पीएफ एक्ट के अंदर क्या ट्रीटमेंट होगा? क्या वो कॉन्ट्रैक्टर लायबल होगा पीएफ कंट्रीब्यूशन के लिए, या प्रिंसिपल एम्प्लॉयर खुद लायबल होगा टू मेक PF contribution in respect of employees? So this case is for this scenario only. So this case is between Misers ITC Limited versus Employees Provident Fund, and it is also a recent case law where Telangana High Court has made judgment in the year 2023. So the facts of this case was that the EPF authority has determined the EPF contribution in respect of contractor laborers holding the principal employer responsible to remit the same. Where the contractor engaged few individuals intermittently, it cannot be considered as employees since the contractors were not allotted independent PF code. The petitioner, being the principal employer, is to cover these employees. So the इस केस में इनिशियली जो ईपीएफ अथॉरिटी का कंसर्न था वो ये था कि सिंस जो पीएफ कोड है वो कॉन्ट्रैक्टर को अलॉट नहीं किए गए, सो अल्टीमेटली जो लायबिलिटी है कंट्रीब्यूशन करने की वो कंपनी यानी प्रिंसिपल एम्प्लॉयर के ऊपर है, ना कि कॉन्ट्रैक्टर के ऊपर। So let's see what are the contentions of both the parties. First one is the company and the other one is the contractor. So according to the company, that is petitioner, and the government, they both have entered into an arrangement where the allotment of coops is made every year. So basically, coops is a specified area where specific forest growth has been made, such as bamboo, timber. So this is the area given by the government to the company to grow certain number of forest growth. So the contention was that the deployment of labor in coops is contingent, irregular, and uncertain, and therefore it was unmanageable by the company. The company entrusting the felling and removing of bamboo to an independent contractor. जो ये अरेंजमेंट था वो एक कंटिंजेंट नेचर का था, मतलब सीजनल नेचर का था। वो इरेगुलर मतलब किसी भी कोई स्पेसिफिक मंथ में ही ये प्रोसेस होता था, ना कि 365 थ्रू आउट द ईयर। सो अल्टीमेटली कंपनी ने ये जो कॉन्ट्रैक्ट है वो इन फेवर ऑफ एक इंडिपेंडेंट कॉन्ट्रैक्टर को हायर करके अलॉट कर दिया। ऑन द अदर हैंड कॉन्ट्रैक्टर का क्या कंटेंशन था? द कॉन्ट्रैक्टर इज इन द ओपिनियन दैट the company has to cover under the EPF Act and the code was allotted under this act, and the company has to enroll all its employees as member. But since the company has to fail to do this, there is no irregularity in the order made by the EPF authority. तो कॉन्ट्रैक्टर का यही कहना था, जो भी ऑर्डर ईपीएफ अथॉरिटी ने दिया है वो बिल्कुल सही है। कंपनी को ही सारे एम्प्लॉयज को जो कॉन्ट्रैक्ट लेबर्स ने हायर किया वो अपने रोल पे करना है, एंड अकॉर्डिंगली कंपनी ही लायबल होगी उनका पीएफ कंट्रीब्यूशन करने के लिए। सो आफ्टर कंसीडरिंग both the contentions of the company as well as contractor, court held that it is the duty of the employer and contractor to maintain the list of employees and to get necessary details of the workmen employed by the contractor. दोनों ही कॉन्ट्रैक्टर और एम्प्लॉयर दोनों की ही लायबिलिटी है कि वो एक प्रॉपर लिस्ट बनाए एम्प्लॉयज की और वर्कमैन की प्रॉपर डिटेल्स मेंटेन करे। हाउएवर द प्राइमरी रिस्पॉन्सिबिलिटी for payment of contribution is on the principal employer, and the contractor is an agent through whom principal employer has to control over the worker. कोर्ट ने ये कहा कि दोनों ही एम्प्लॉयर और कॉन्ट्रैक्टर को मेंटेन करनी है लिस्ट एम्प्लॉयज की, लेकिन जो प्राइमरी रिस्पॉन्सिबिलिटी होगी वो प्रिंसिपल एम्प्लॉयर के ऊपर ही होगी अगर कॉन्ट्रैक्टर फेल कर जाता है कंट्रीब्यूशन करने के लिए। कॉन्ट्रैक्टर इज जस्ट एक्टिंग एज एन एजेंट through whom principal employer has to control over the worker. प्रिंसिपल एम्प्लॉयर का कंट्रोल वर्कर के ऊपर थ्रू कॉन्ट्रैक्टर है, जो कि एक सिर्फ एजेंट के तौर पे काम कर रहा है। जो भी कॉन्ट्रैक्टर काम करता है वो और इंस्ट्रक्शंस ऑफ द कंपनी यानी प्रिंसिपल एम्प्लॉयर्स के इंस्ट्रक्शंस पे काम करता है। देयरफॉर इट इज द ड्यूटी ऑफ द एस्टेब्लिशमेंट टू गेट the temporary identity certificate issued to the workman and to pay contribution accordingly. So crux of this case was that अगर किसी भी कंपनी कोई भी कंपनी कॉन्ट्रैक्टर हायर करती है और कॉन्ट्रैक्टर किसी भी कारण फेल कर जाता है कंट्रीब्यूशन पे करने के लिए, सो द अल्टीमेटली लायबिलिटी वुड बी ट्रांसफर्ड टू द कंपनी इटसेल्फ टू मेक contributions. Now our next case law is regarding to the splitting of minimum wages under the EPF Act. The key issue decided is regarding the splitting of minimum wages, and the case is between Assistant Provident Fund Commissioner versus G4S Security Company, and the judgment is given by the Supreme Court on 17th August 2023. So let's see what are the contentions of both the company as well as PF department. So according to the PF department in this case, PF department is of the opinion that it is the minimum wage defined under the Minimum Wage Act which is to be taken into considering for determining the PF contribution. PF डिपार्टमेंट का ये कहना था कि मिनिमम वेज को ही कंसीडर करना चाहिए। मिनिमम वेज की जो डेफिनेशन प्रिस्क्राइब की है मिनिमम वेजेस एक्ट के अंदर, उसी को कंसीडर करना चाहिए इन ऑर्डर टू मेक पीएफ कंट्रीब्यूशन। And the second point is by not including the allowances in the basic wage, the respondent has deflated the share of the employee's contribution. सो बेसिकली जो कंटेंशन था पीएफ डिपार्टमेंट का वो ये था कि फर्स्ट जो मिनिमम वेज डिफाइन किया वो कंसीडर करना चाहिए कंपनी को, एंड सेकेंडली बाय नॉट कंसीडरिंग दैट डेफिनेशन, कंपनी का ये कंटेंशन है कि उनको जस्ट इन ऑर्डर टू रिड्यूस the contribution which they are supposed to make to the employees, just to deflate the share of employees contribution. On the other hand, the contention of the G4S security company was that the Minimum Wage Act is distinct from that of basic wage under Section 2B of Employees Provident Fund Act, and the provisions of one act cannot be read into other when the legislative intent is clear, since the Provident Fund Act was enacted subsequent to the enactment of Minimum Wage Act. तो जो कंपनी का कंटेंशन था वो ये था कि दोनों ही मिनिमम वेज एक्ट और प्रोविडेंट फंड एक्ट दोनों का ही ऑब्जेक्टिव अलग है। मिनिमम वेजेस का ऑब्जेक्टिव बिल्कुल ही अलग है पीएफ एक्ट से, और सब्सिक्वेंटली जो पीएफ एक्ट है उसमें जो बेसिक वेज डेफिनेशन है उसी को कंसीडर करना चाहिए, ना कि मिनिमम वेज की डेफिनेशन को। So the court, after considering both the parties' contention, company as well as PF department, court held that there was no compulsion to hold that the definition of basic wage should be equated with the definition of minimum wage under Minimum Wage Act. No doubt, wage less than minimum wage is violation of law and cannot be paid, but it does not imply for the calculation of contribution of EPF contribution. तो कोर्ट का ये कहना था कि ये कोई कंपल्शन नहीं है कि मिनिमम वेज की डेफिनेशन को ही कंसीडर करना है अंडर पीएफ एक्ट, सिंस बेसिक वेज डेफिनेशन is prescribed under the PF Act, the employer has to consider that only to make the PF contribution. And secondly, मिनिमम वेज से कम हम एम्प्लॉय को वेज नहीं दे सकते, वो सही है, लेकिन इसका मतलब यही नहीं है कि आपको मिनिमम वेज डेफिनेशन ही कंसीडर करनी है, दोनों का ऑब्जेक्ट बिल्कुल अलग है। And the second point is that the Minimum Wage Act provides for the definition of wage which is distinct from the term basic wage, which within its ambit include house rent allowance, but it does not include certain other allowance. तो जो मिनिमम वेज डेफिनेशन है, मिनिमम वेज की डेफिनेशन जो मिनिमम वेज के अंडर प्रिस्क्राइब की है, उसमें ये जो कंपोनेंट है एचआरए का, हाउस रेंट अलाउंस, वो इंक्लूड होता है। बट अगर आप बेसिक वेज की डेफिनेशन कंसीडर करोगे, जो पीएफ एक्ट के अंदर है, उसमें ये स्पेसिफिकली एक्सक्लूड होता है। तो ये कहना कि कंपनी मिनिमम वेज की डेफिनेशन कंसीडर नहीं कर रही जस्ट टू रिड्यूस इंप्लॉय कंट्रीब्यूशन, ये बिल्कुल गलत है। दोनों एक्ट का प्रोविजंस बिल्कुल अलग है, दोनों के ऑब्जेक्टिव बिल्कुल अलग है। तो फाइनली द क्रक्स ऑफ दिस केस वाज दैट employer has to consider only the term basic wages in order to make PF contribution to employee. They are not entitled to go to the minimum wage definition prescribed under minimum wage act. So our next case is also very important and recent case law in respect of international workers defined under the PF Act. So this case is made on international workers and the judgment is given by the Karnataka High Court on 25th April 2024. So basically, two paras, para 43 and para 83, is introduced by the PF department few years back, which is not considered by the court, which is in violation of Article 14. So let's see what is it all about. So let's understand what does it mean by international worker first. So an international worker is an Indian employee who works in a foreign country with which India has entered into a bilateral social security agreement, or an employee working in India not holding an Indian passport. Under the special provisions, international workers was required to be covered on his entire salary, even for pensionary benefits, and the amount payable lying to his credit would be payable on him when he leaves India, only attending the age of 58 years. The ceiling for employees other than international workers for becoming the member of the scheme is 15,000. So basically जो इंटरनेशनल वर्कर्स है, वो कोई भी इंडियन एम्प्लॉय अगर बाहर जाके काम करता है किसी भी कंट्री में जिसके साथ इंडिया ने एक बायलैटरल सोशल सिक्योरिटी एग्रीमेंट एग्जीक्यूट किया, सो बेसिकली देयर आर अराउंड 15 to 18 कंट्रीज जिसके साथ इंडिया का बायलैटरल सोशल सिक्योरिटी एग्रीमेंट एग्जीक्यूट हुआ है। तो अगर वो बाहर जाके काम करता है, ही इज डीम्ड टू बी एन इंटरनेशनल वर्कर। But the problem in this case was that for the domestic employees, they have provided a ceiling limit of 15,000 under this PF Act. But for international workers, they have not provided any ceiling limit. Suppose a foreign worker comes in India for some technical or some other kind of work and working in India, his gross salary is supposed to lakh, then the contribution is required to be made on entire gross salary. There is no ceiling provided for those workers. So there is a discrimination made between the domestic workers as well as international workers. For domestic workers, you are giving contribution on a ceiling of 15,000. But on the other hand, if some workers come from outside India, you are giving on the entire gross salary. So the cause of action which arose in this case was that court held that para 83 of EPF scheme and para 43A of employees pension scheme as unconstitutional and hit by Article 14 of the Constitution of India. Article 14 basically provides right to equality. So it is against Article 14 of the Constitution of India. This act provides for the coverage of the weaker section of society where there is a ceiling limit of 15,000 per month and no salary ceiling limit for international workers, which is in contravention of law. So basically जो objective है PF Act का वो एक तरीके का benefit provide करना है weaker sections of society को by giving some kind of benefits which they can attain after their retirement. ना कि पीएफ ऑब्जेक्टिव पीएफ एक्ट का ये ऑब्जेक्टिव है टू गिव हैवी बर्डन ऑन द एम्प्लॉयर टू डिडक्ट पीएफ ऑन द ग्रॉस सैलरी. So after considering the whole objective of this act, court held that Para 83 of PPF scheme and Para 43 of employees pension scheme are unconstitutional. And finally, court struck down these two paras as unconstitutional and arbitrary and said that all orders passed in this case was unenforceable because it is hit by Article 14. So we cannot make discrimination between the domestic as well as international workers. So right now these two paras have been struck down by the court and common benefits are provided to both international as well as domestic workers.
The second thing is that regarding voluntary coverage under the EPF Act, this is the case law. So by this case law, you will be able to understand what is the voluntary coverage and what are the terms and conditions over there. So this case law is between the Messrs Consumer Electronics Punjab Limited versus the presiding officer EPF Appellate Tribunal, Punjab and Haryana High Court. This judgment was passed in 15th November 2023. The brief case of this is that the worker who joined as an account officer on 9th January 1991 in the petitioner company and promoted as a chief executive on 30th August 2001 and retired on 31st of January 2010. The petitioner applied to the EPF authority So the petitioner applied to the EPF authority seeking voluntary coverage of their establishment with effect from 1st of May 1999. What is the contention of the worker? The worker contended that the petitioner company is the wholly owned subsidiary of Messrs Punjab Information and Communication Technology Limited. The premises is owned by PICTCL and certain officers of PICTCL working managing the affairs of the petitioner company. Contention of the petitioner counsel is that the petitioner company was covered under the provisions of EPF Act on the basis of application submitted by the petitioner company on 1st May 1999 and not from any date prior to 1st May 1999. According to EPF, dues required to be paid from the date of voluntary coverage only. What was the case upheld by the EPF Appellate Tribunal? There is no straight jacket formula laid down for considering as the whether two units should be considered one establishment under the EPF Act. Whether both companies, my voice is audible or not?
Audible, sir.
Audible? Okay. Oh, so Mr. Akshay, I can see you. People are audible.
Audible, sir. Audible.
Okay, no, thank you. So the upheld decision was that there is no straight jacket formula laid down for considering as to whether two units should be considered one stabilization under the EPF Act. There is no any okay. So there is nothing is mentioned in the EPF Act whether there is two stabilization. There are two different entity, and there is a two different identity with the same name or the same honor will be considered as a one establishment or not. Where both companies have common management and 100% investment by the parent company in the petitioner company. The letterhead of the companies bears the same telephone numbers. The annual accounts are maintained by the common employees. Where both companies have common office, business place, and employees are under the common management and enjoys same pay scale, then clubbing of two companies are not illegal. So there are two things. Let's go for the conclusion also. So when we talk about the conclusion, this is mentioned that hence, as the writ petition clearly indicated that the petitioner company is the 100% owned company of PICTCL and there is a unity of management and employment, the instant writ petition fails and the same is dismissed. So the contention, what is the meaning that what is the crux of this judgment is that there are two different company, but their management is the same. Their entire activity which is related to the employment, accounting, employee salary, their bookkeeping, the complete top management, each and everything is the same. But they are running the business by the two names, by X Limited and Y Limited. They have a two different identity, but their work is common. So the EPF authority says that in this condition, both companies will be considered as one company. This was the contention of this case law. Let's move ahead. The Employee Provident Fund, EPF and Miscellaneous Provision Act. Someone is waiting. So there is some advice to all of the HR professionals who we are working. This is an advice to all of you. Avoid paying the below allowances which is mentioned like a special allowance, miscellaneous allowance, supplementary allowance, other allowance, fitment allowance, X, Y, Z. Lots of allowances we are maintaining in our CTC structure. Let's avoid those allowances to maintain in your CTC. As much as you minimize the structure, you will be on a safer zone. There will be no any question on you. However, if you want to keep the allowances, ensure that all those allowances should be policy based. And if these are the policy based, will not come under the PF wages. Say for example, if you are giving the washing allowance to your worker, there should be a policy that if company has provided uniform to its employees who have been working at a place like boiler or workshop or similar to that working condition, and you are paying the washing allowance within the policy to the specific people, then it will not come under the meaning of the PF wages. The conveyance transport allowance, company has not provided company's transfer facility for attending duties to their employees. So the management has decided to compensate the public transport allowance. If this is the nature, what are the conditions to be paid? What are the amount to be paid? This should be completely mentioned in the policy. And if this is driven with the policy, it will not come under the definition of PFH. Incentive or variable payment. Such incentive payment should be variable or it should be linked to any production scheme or sales incentive or data punching incentive or customer satisfaction of the company. If the incentive or the variable payment is in the nature of the variable, then these will not come under the definition of PF wage. But if this is regularly you are paying to any employee without any circumstances or without any justification, without any specification, then these all incentives will come under the definition of PF wage. This we need to ensure. Payment of bonus and commissions if paid monthly. Avoid paying statutory bonus on a month-to-month basis. However, Puja, Diwali, religious bonus can be given as per Payment of Bonus Act 1965. Payment of commission incentives can be given quarterly according to a written policy of the company. So whatever I have told you, this should be driven with the policy only. If there is policy, if there are conditions which is made, how to pay, then this will not come under the definition of PF wage. Else, it will be considered. And then you will become in a trouble when EPF raise any query or raise any inspection. Then you will come in trouble. And how you will justify these? That the allowances which you are paying to the employee will not come under the definition of wages. Why you didn't consider as a wage? So we need to ensure this kind of thing when we are preparing any salary structure for our employees, for our workers, or anyone. Let's move ahead. Who are the excluded employees? Just give me a second. So the another definition is the excluded employees. Who are excluded, who are included? This is the biggest question for us. Any employee of the establishment to whom both the conditions apply at the time of the joining. What are the conditions? If pay or basic wage is more than 15,000 per month and does not have any current EPF or EPS balance under the EPF and MP Act 1952. If these are the two conditions completely verified to that particular employee who are going to join your organization, then he can be excluded. Else, he will be included. He will be considered under the EPF contribution and he has to fall under that. If anyone is coming to you and saying that please exclude me from the EPF, then you need to ask, give me the proof or give me the evidence that you are not the member of the EPF. And how you can collect the EPF confirmation or from the employee? When we are checking the employee EPF declaration form, that is form 11. When you check the form 11, the point number 9 and 10, it clearly mentioned that if you are earlier the member of PF or not, if you are earlier member of EPS or not, as per the new form of the form 11, EPF declaration form, then you can check point number 9 and 10. It's saying that you have to mark a tick that earlier you were a member of EPF or not, whether you were earlier a member of EPS or not, yes or no. If employee is declaring in that declaration form, you can exclude it. Asking that additionally to provide the PF bank PF statement, passbook statement, along with the Aadhaar details. So whenever you are registering any employee at the EPF portal, you need to enter his Aadhaar details and match it. Whenever you try to enter the details, it will again show the pop-up error that if the employee was earlier a member of EPF, it will show you. Then you can cross-check with the Form 11 as well. Still, at any condition, if system is not showing any pop-up issue or error, then still you are in a safe zone because you have checked the Form 11, which is documentary and submitted by the employee. There is no any obligation on you. And secondly, we should remit pension contribution in account number 10 for only eligible employees. For only those employees who are eligible for the EPS contribution, was the earlier member of the EPS, then only we can consider that. But how will you determine that the new joiner is eligible to become a pension scheme or not? This is the next question. How you can identify? Then to identify this, you need to check these chart. The person who joined before, who was the member of the EPS. This is clear cut. But the new joiner who joined after 1st September 2014, there are some conditions. If basic wages is more than 15,000 per month, then employee will not be member of the pension. This is a scheme which was introduced in 2014. If any employee is joining first time employment and his basic wage as per the EPF definition, the peer wage is more than 15,000 basic wage, then he will not be a member of EPS. Pension member नहीं होगा वो. लेकिन अगर वो member होता है तो उसका पहले कोई ना कोई रिकॉर्ड होना चाहिए, फर्स्ट टाइम पीएफ मेंबर होना चाहिए. अगर वो I'm audible to everyone. We are facing some technical
Yes.
Yes.
Okay, done. Thank you. Just hold a second. I'm facing some technical issue. I really excuse that I was facing some technical issue. Some network issues there. So we were discussing about the new joiner who joined after 1st of September 2014. Then we need to check his basic wage is over and above than 15,000, then he will not be the member of EPS. If below than 15,000, then he will be the member of EPS. If the employee is not the new joiner, he has a previous employment and before that 2014, then we have to check the EPF passbook, form number 11, the EPS declaration, whether there is a contribution to the pension or not. This we need to identify. The main agenda for this chart is to show you that the employee who was joining after 2014 as a new employment, as a new employee in your organization, and if his basic wage is more than 15,000, then he will not be a member of EPS at any condition. This we need to ensure, especially for the new employee, the person who just starting their career, their job on the first time. Now we are coming to the next point is the ESIC. What is the ESIC eligibility and category?
Now, Employee State Insurance Act 1948, it is another social security legislation, just I talked about PF. So the objective of this ESIC Act is to provide medical benefits and facilities to the employees and their dependents in case of employment injury, full or partial disability, maternity, or in case of death. So for the purpose of this, ESIC has established various ESIC hospitals and dispensary to provide benefits to the weaker sections of the society. So let's talk about the eligibility criteria and the contributions which are required to be made under this act. To come under the preview of this act, the monthly gross wage should be less than rupees 21,000 per month. It should be less than 21,000 and the employees need to contribute 0.75% on the total monthly wages and the employer need to contribute 3.25% on the total monthly wages. Now let's talk about the key features and the benefits which are provided under this employee state insurance scheme. So under this scheme, the insured medical expenses are covered through affordable and reasonable healthcare facilities, and the worker or the employee is covered from the day one of the person's employment. In case of women, the maternity benefit under this scheme, the beneficiary can avail 100% of the daily wages for up to 26 weeks, which can be extended to a further 1 month based on the medical advice. And in case of miscarriage, the benefit is 6 weeks, while in the case of adoption, it is 12 weeks. In case of temporary disablement of the worker, they are eligible for a monthly wage of 90% until they recover. And in the case of permanent disability, 90% of the monthly wage can be availed for the entire life. If we talk about sickness benefits during the medical leave, this scheme offers cash flow during the set period and the worker can avail 70% of the daily wage for a maximum of 91 days, and this can be availed in 2 consecutive periods.